Is that because that's how they did it?
The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council, as well as to those who are watching us through our live stream channel. We look forward to the arguments of council this morning, and I would ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, February 5th, 2021 consists of one case. Appeal numbers 120620 and 120622, State of Kansas versus Stephen M. Bodine, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court. James Latta of the Appellate Defender's Office, representing Stephen Bodine, ready for argument.
May it please the court. Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Mr. Latta, you may proceed with your argument.
Thank you, Madam Chief Justice, and may it please the court. This case finds its way to this court on direct appeal from two alternative counts of felony murder and 2 alternative counts of aggravated kidnapping, among other convictions, but those are the only convictions I'm arguing about in my brief. As a brief recitation for the facts aren't too important because my issues are mostly legal, but to start from the beginning, the facts of this case are profoundly disturbing and horrific. This case began with Miranda Miller giving birth to a 3-year-old boy. The boy and his biological father, who's not my client, and Miranda Miller were estranged. They did not see each other very often. And this also involves the deaths of this 3-year-old boy. And a few months before this boy's death, my client, Bodine, and Miranda Miller became romantically involved, and Bodine moved into the house with Miller. Around that same time, father was becoming more involved in the child's life. And also around that time, there were allegations of extreme child abuse from about March 2017 to May 2017. And eventually those extreme allegations of child abuse, which some were caught on video and recorded and admitted at trial, ultimately led to the death of this 3-year-old boy. And that death occurred between May 18th and 22nd, 2017. The exact date isn't sure because Miranda Miller, the only one who testified between her and my client, was not sure of the date due to her heavy drug use. And so that's how we got to this case here. And from the beginning, Your Honors, I understand I've made some tough and novel arguments in my briefs, and I'd like to start with what I think is, and I would take any direction from this court if Your Honors would like to talk about something different. I'm certainly not going to try to talk about every issue in my brief, but I'd like to jump into one of the toughest issues I raised, which is that the aiding and abetting instruction allows the state to circumvent the element that the defendant personally perpetrated the crime. And the Kansas crimes are all written as definitions. So it never talks about who actually committed the crime. But I think it's safe to say that we know it's self-evident that we know the legislature meant the defendant committed the crime. And we know this from because who else could they have wanted? I mean, when we read the jury instructions, they always say the defendant did X. Well, if the defendant personally committing the crime isn't an element of the underlying crime, why is that instruction legally accurate? why is an alibi defense any good? How does the jury can acquit of someone if the defendant actually committing the crime isn't an element of the underlying crime? I mean, I don't think we'd say it's jury nullification every time the jury decides the defendant didn't actually personally commit the crime. And to buttress that, there would be no need for an aiding and abetting statute or instruction if there wasn't an understood element of the defendant actually committing the crime. The definitions of the crimes do not limit themselves expressly to the defendant. So we could put someone on trial, the state could stand up and object and say, well, the statute doesn't require the defendant actually committed it. So this alibi defense is not even part of it's not even relevant. I mean,
Mr.
I don't
Lana, may I ask a question? I just want to make clear, or I just want to understand, this is your issue number 4, which is that the aiding and abetting statute is facially unconstitutional because it relieves the state of proving every element of the crime.
That's correct.
Okay, so the vehicle which you're getting there is that 215210 is facially unconstitutional.
That's correct. And that's because every crime, I've looked at as many as I could, every crime in Kansas is written as a definition. And my argument is that every crime, an understood element is the defendant personally committing that crime. And so every time that aiding and abetting statute is used in Kansas, it is unconstitutional in every instance. And so that's how I get to my facial challenge.
Doesn't the aiding and abetting statute just effectively mean that an aider and abetter did personally commit the crime?
I don't think so. I think the aiding and abetting statute, I mean, as this court has said, it doesn't have any element, it's not a crime, and it extends liability. So, I mean, you could...
If you aid and abet, you are effectively standing in the shoes of the individual that, to use your language, personally committed the crime.
While you may be, I understand that statute extends liability and does that and puts them in that position, I'm still saying an element of these underlying statutes is still that the actual person on trial personally committed every element. And because the statute is not alternative means, there's no elements for aiding and abetting. Every time you prove someone.
Let's just say you're right about that. You're right. Let's, for sake of argument, you've convinced me that the statutes operate the way you say they do. Why is that unconstitutional?
It's unconstitutional because whenever someone proves that there's an aider and abetter, that they were an accessory and didn't actually commit the crime, the state is not proving the understood element that they were charged with. They were charged with, every time you're charged with a Kansas crime, you're charged with personally perpetrating that crime.
Can't the legislature change the elements as it sees fit?
Yes, they can, and that's I think that's the problem. Is if they made the aiding and abetting statute an actual crime, we wouldn't have a problem. But this court has interpreted it as it's not a crime. I mean, I want to be clear. This is not an alternative means argument. I believe that because this court has said that the aiding and abetting statute is not alternative means, it doesn't present distinct elements, it's not its own crime, that this separates my argument from the many times before this court has heard somewhat similar issues. And if there's no questions on that one, I'll move on to another issue. The next issue I'd talk about is the one involving felony murder doctrine and the aiding and abetting statute, wherein we talk about aiding and abetting. I believe the felony murder statute, the legislature only intended for those who actually are involved during the felony. And the aiding and abetting statute in the instruction has this language about before or after. And I think that makes the instruction legally inappropriate, because based on the plain language of the felony murder statute and how what was instructed here was in the commission of a felony, whenever we're allowing someone to aid or abet before and not actually during the felony, I think that also relieves the state of the burden based in the statute. I think this court has previously, as I cited in my brief, construed the felony murder statute narrowly. And I don't think, for example, I don't think that the legislature meant that if someone loaned someone a car a week before to commit a robbery, and during that robbery someone is killed, I don't think the legislature meant for that aiding and abetting to also be murder. That was just be aiding and abetting the robbery. I think the legislature intended to narrowly construe felony murder in the commission of, which means just during the actual events when the victim died. And just the last issue I'd touch on is about the aiding and abetting statute, where it incorporates the mental state of the crime you're charged with. And here we're talking about the aggravated endangering a child crime, and in combination with felony murder and the aiding and abetting statute. And previously, the aiding and abetting statute has been amended to where we now incorporate the mental state of the underlying crime. So as I pointed out in my brief, now for aggravated child endangerment, which is a reckless crime, you'd have to show that they recklessly, intentionally aided someone. And so I think this court has recognized that that's legally impossible. And I would just point out that this court has also said that the KSA, I think it's 215202, does not, while it says that if you commit a crime intentionally, you've also proven knowingly and reckless, I think this court has recently said that that does not allow for a logically impossible crime to come into existence. And so I would just point that out now. And if this court doesn't have any questions, I'm through with my argument.
Assuming that to be true, wasn't it defense counsel who insisted on having the aiding and abetting instruction for the ag endangerment charge?
It was. That is correct. And the state argues invited error in their brief. And in my reply brief, it's my position that instructions can't bring into an existence a logically impossible crime. So even though the instructions, if this was an instructional argument, I couldn't make it. But I don't think we can allow instructions to bring in crimes that aren't possible. If this led to a legally possible crime, then I think I would be barred. But this argument has to transcend the instructions, because I don't think we can allow lawyers and judges to accidentally, that would be like legislating. We're letting them bring in crimes that aren't even possible.
And counsel, what's the impossibility there? Why isn't it possible to intentionally aid and abet reckless conduct? Is that your position?
Yes. And that's because before it used to be, and the state cites those cases in their brief, but the legislature amended the statute to where you actually have to incorporate the underlying mental state with the other conduct. So we're incorporating, in this instance, we're incorporating reckless, which is unintentional, into intentionally aiding. So I don't understand how you intentionally aid someone to commit a crime.
If I bring a group of individuals to a party that I know that are amped up, angry, and are looking to start trouble, and that's the reason I bring them there, why isn't that intentionally aiding a reckless conduct if they then engage in altercations?
Well, it seems like, I don't see where the unintentional, I'm sorry, Justice, I don't see where the unintentional conduct is. They were intentionally brought there, and you knew they were rowdy to get everyone in a fight.
To facilitate reckless conduct.
Well, I don't think that would be possible, because that would be intentional. There was no, maybe I'm misunderstanding your question. I'm sorry, but I just don't.
I understand your response. Thanks.
Oh, okay, thank you.
Justice Sanders, did you still have a question?
I did. It was kind of along the same lines. So what I don't, is it logically possible for the defendant to have intentionally aided, or sorry, yeah, Miller in recklessly causing or permitting EB to be put in a situation in which his life, body, or health was endangered?
I think it might have been possible for Bodine to intentionally put Miller in a position where she unintentionally did something. But my argument is that with the incorporation of the mental state, it's based on the defendant. The defendant has to intentionally aid someone. I don't think based on the plain language of the statute, my reading of it, it's not that the defendant has to intentionally put someone in a place to do something unintentional. The defendant has to do both, because it says with the mental culpability of the underlying crime. So that's why it's logically impossible to me.
I'm sorry, what is the significance of the "or" in that statute? It says the first part is acting with the mental culpability required for the commission thereof, advises, hires, counsels, or procures the other to commit the crime. And then we have "or," and then we have intentionally aids. It seems to me that the mental state provision that I think you are referring to applies only to the first part of the sentence, not the last. Do you read it differently, I take it?
I'm sorry, Justice, I just have now the statute pulled up. Would you mind repeating
Certainly,
that?
yeah. So looking at A, the first part begins with the person acting with the mental culpability. And I think you have been focusing on that legislative change where they brought that phrase in. Acting with the mental culpability required for the commission thereof, advises, hires, counsels, or procures the other to commit the crime. And then there's the word "or," and then the phrase intentionally aids the other. It's with the "or," does that change the mental state in the two, what precedes the "or" and what follows the "or"?
I don't think it does. I'm not saying that the intentionally from aids goes back to the other words before the "or," but as I point out in my brief, I don't know how you can advise, hire, counsel, procure someone unintentionally. I mean,
But what I understood you to say, that your argument's different than our past case law because of the legislative change that changed that first portion. And I'm trying to understand how the argument you were making today is different than the past case law. I guess is bottom line.
Well, because the statute has changed since then. Back in the previous case law, at least that cited by the state that I read, the phrase "acting with the mental culpability required for the commission thereof" wasn't part of the aiding and abetting statute back then. So that's how the examples from the other justices could happen. You could intentionally take someone somewhere knowing that they might do something unintentional. But now I read it as the defendant has to actually act with the underlying culpability required as well. I mean, you'd have to recklessly advise someone. You'd have to unintentionally give someone advice. And to me, advice, I mean, if you're not giving advice if you don't mean to. I'm hoping I'm answering your question, Justice.
Well, I think you advise to commit the crime. It's not that you're just giving advice. You're actually directing them to commit the crime. And
yes, I agree. And that's why I don't think that you can recklessly advise someone. And with my reading of the statute is the mental culpability required, which would be reckless for aggravated endangerment, is incorporated. So I read it as saying recklessly advise someone, which to me means unintentionally advise someone.
if I don't understand the possible consequences of an act, but I advise you to do the act, is that a reckless advice? Am I recklessly advising you to commit a crime?
No, because I believe reckless goes to the act. If you know you're advising someone, I don't believe reckless goes to the result as the statute's written.
Let me give you an example with one of my kids from a long time ago. One kid says to another kid, "Let's go throw rocks across the street. Come on." let's go, let's go. Please come, let's go. So they throw rocks across the street and it hits the windshield of our neighbor's car. Okay, which where they were throwing across the street, there was the car. Isn't that advising, hiring or counseling, recklessly, with the same mental culpability, advising, hiring, counseling, or procures the other to commit a crime or intentionally aids the other person?
I would disagree, and I think where our disagreement's coming from is I think the reckless culpability goes to the actual action of asking. Right. It goes. So I don't think you can. I don't think that you can unintentionally ask someone to go throw rocks. They intentionally did that, and so I don't think. My reading is the recklessness does not go to the result of the rock actually hitting the windshield. You would have to ask someone to do something unintentionally. But in that scenario, to me, it's they intentionally asked him to go throw rocks. And that's why it's logically impossible to unintentionally say, let's go do something.
Other questions? Okay, thank you, counsel. Mr. Maloney?
May it please the court, Assistant District Attorney Matt Maloney for the state. I will proceed by taking the issues in the order that opposing counsel has argued them, unless the court has other questions in mind. So beginning with issue 4, which is the aiding and abetting statute, our primary position on that is that this issue is not properly before the court. I think defense counsel acknowledged that this is an argument that's being raised for the first time on appeal. In his brief, he attempted to argue that this court should nevertheless address it because it is finally determinative of the case, and because addressing it is necessary to prevent the denial of a fundamental right. Our position is that neither of those exceptions apply, specifically because in this case, there is overwhelming evidence that the defendant was acting not simply as an aider and abetter, but as a principal. And therefore, it's not necessary to sort through this constitutionality of the aiding and abetting statute in this case, because it is not finally determinative of the case. Even in a hypothetical world in which he could succeed on his challenge to the aiding and abetting statute, it would not afford him relief in this case because he acted as a principal, and therefore it's not necessary to address this matter. So our position first and foremost is that he does not meet either of the two exceptions that he seeks to apply in this case, and that therefore this court should not address the merits. Just briefly, I will touch on the merits out of an abundance of caution, as I did in the brief. And I think this court, some of the questions that this court asked counsel really gets at the same argument that I was making in the brief, which is that the statute does not relieve the state's burden of proof on an element. Instead, it's simply a well-established theory of criminal liability under which everybody participating, whether as the principal or as an aider and abetter, does share the same criminal responsibility. And it's a statute and a theory of liability that has been well established at both the state and federal level. I think, as Justice Stegall pointed out, the aiding and abet statute itself does itself mean that the defendant, from a legal perspective, did personally commit the crime. I think Justice Stegall, as you phrased it, it essentially puts the defendant as standing in the shoes of the person who pulled the trigger or inflicted the fatal stab wounds or whatever the case might be in a given situation. So our position is that it doesn't relieve the state of the burden of proving an element. It's simply a theory of criminal liability that does hold the defendant personally responsible, regardless of who actually inflicted the fatal blow. And also, as Your Honor pointed out, I think it also, the defendant's argument is that it's unconstitutional. And I struggle to see how the legislature deciding what elements apply is a constitutional issue. As Your Honor pointed out, the legislature is free to define crimes and determine theories of criminal liability here. And the fact that the defendant might not like the aiding and abetting liability does not raise a constitutional concern. The next issue that counsel argued was issue 3, which was the was committing language in the felony murder instruction. First, I would point out that this argument ignores the language of the felony murder instruction itself. He's focusing on the language in the aiding and abetting statute, but the felony murder instruction itself had language saying that was committing the offense. And so I think that right there, when you're looking at the instructions as a whole, really takes care of the issue that the defendant is trying to assert in his brief and trying to challenge. Second, I would note that the aiding and abetting instruction given in this case is consistent not only with the PIC instruction, which, as this court knows, is highly recommended that PIC instructions are followed, but it's also consistent with this court's case law in aiding and abetting cases in the context of felony murder. So the instruction is consistent with this court's case law, with the instruction that's recommended by a panel of experts. And again, when you look at the instructions as a whole, I think they do fairly state the law to the jurors. And finally, while in no way conceding that the instruction was inappropriate, as a harmless error argument, I noted in the brief that, again, there's overwhelming evidence in this case that the defendant was acting as a principal. I set that evidence out in the brief. I'm sure this court's well familiar with it. The defendant personally inflicted all sorts of abuse on the victim in this case, not only in the weeks and months leading up to the child's death, but there was testimony about the hours and moments immediately preceding the death. The defendant was very much personally involved as a principal in this crime. And so even if by some chance there's an error in the aiding and abetting instruction, it does not lead to reversal in this case.
Given that, Mr. Maloney, what was I've been struggling to understand why aiding and abetting was even given in this case, given that that's your position and the strength of the direct evidence of Mr. Bodine being the principal.
I think my only answer to that would simply be out of an abundance of caution. Obviously, we can look back at this record now and all agree, I think, that there was overwhelming evidence that the defendant was a principal. But obviously, when a case is charged and even once it gets to trial and the evidence comes in, I think the state obviously is well within its right to also include the aid and abet instruction, because there was evidence that the victim's mother also at various points did inflict abuse on the victim, and because there was some uncertainty regarding the exact timing of death. And so I think because of that and the uncertainty and the fact that obviously nobody ever knows exactly what a jury will decide, I think just out of an abundance of caution, that aiding and abetting instruction was given. But that doesn't change the fact that when we're looking at this issue on appeal, that there was such overwhelming evidence that the defendant was a principal, that even if this court were to decide that there was no need for the aiding and abetting instruction, that any error in that instruction certainly did not in any way affect the verdict in this case. The final argument that the defendant raised was issue 5, which challenges the use of the aiding and abetting instruction with respect to the reckless offense of endangering a child. And our primary position is very straightforward, that this is a textbook example of a situation where the invited error rule should preclude review of this issue. this is not a case where we have to speculate about whether the defense made a strategic decision to have the court instruct on this theory of criminal liability, or if it was just an oversight. Because at the instruction conference, the district court very clearly and specifically broached this specific subject of whether it was appropriate to issue aiding and abetting instruction in the context of a reckless crime. So the court brought the matter to defendant's attention, and defense counsel very clearly said that he did in fact want the court to instruct on this theory. And that's the exact scenario that invited error is designed to prevent. It's not to say whether or not it was in fact error. It's simply to say that even if it was error, the defendant cannot benefit when he has led the court down that path. And so our position is that because the defendant very specifically asked the court to instruct on this criminal liability theory, he is not now entitled to say that that created a problem that leads to reversible error. And so therefore our position is that this court should not address the theoretical argument that the defendant is making, and should instead say that the issue is not properly before it because the defendant got the exact instruction that he desired. Now, alternatively, on the merits, as I cited in our brief on pages 21 and 22, our position is that this court has previously addressed this issue on at least 2 occasions in Garza and Friday, and has rejected this argument. The case law that the defendant cited in his brief had to do with aiding and abetting in the context of attempts. But the cases that we rely on are cases that deal with the specific situation here, which is aiding and abetting a completed crime that is a reckless one. Those cases remain good law, and specifically in Friday, this court was asked by the defendant to revisit Garza, and it expressly declined to overturn that case and said that it remained good law. And I think indicated that in Friday in particular, this court said that the issue with the problem with the defendant's argument was that the underlying crime of reckless second-degree murder was not a specific intent offense. And so again, this court has had the opportunity to address this on multiple occasions and has chosen to reject the defendant's argument. And the defendant, in his brief, did not address those cases and instead cited cases dealing with attempted crimes. So those would be our 2 primary arguments. I also noted in the brief that his felony murder conviction also rested upon an independent legal theory, which is the abuse of a child as the underlying offense. And so that too would make this issue something that the court really may not address, because there's this independent theory that he was convicted of felony murder under. And so even if he could somehow cast doubt upon this particular theory, it would not afford him relief. And then as a final backup alternative argument, as I already touched upon in a previous issue, the evidence in this case was so overwhelming that the defendant acted as a principal that we need not get into the aiding and abetting instruction, because it simply would not have had any impact on the outcome of the trial. Again, to go back to Justice Rosen's question, I think the fact that the state chose to include the aiding and abetting theory and instruction was simply out of an abundance of caution, and perhaps because of some of the uncertainty regarding the exact time of the victim's death. But again, that doesn't change the fact that there was overwhelming evidence that the defendant was a principal in this case. He was the person that was the ringleader in all of this abuse, even on the occasions in which the victim's mother participated in the abuse. She was doing so because she was personally being abused, and she, I think, testified that she actually felt like in some occasions she was essentially helping the victim, because when she perpetrated the abuse, it was likely to be far less severe than if the defendant himself did it. But she was always acting at his behest. The defendant was the principal in this case. And so any any question regarding the aiding and abetting instruction in this case does not lead to any reversal because it would be harmless beyond any doubt. If there are no further questions from the court, our position is that the defendant has failed to show error, let alone reversible error. And we would ask that this court reject all of his arguments and affirm his convictions.
Any questions for Mr. Maloney? Thank you, counsel. Mr. Latta, you reserve 3 minutes. You are muted, sir.
Sorry about that. I don't believe I have anything to add other than what I said in my briefs and in my opening argument here, unless there's any questions from the court.
Are there any questions? It doesn't appear so. So thank you, Mr. Latta, and thank you, Mr. Maloney, for your arguments. The court will take this appeal under advisement. We are now in recess until